Hello, and welcome to all the participants who have registered to join us today for this expert roundtable on the policy on the crime against humanity of gender persecution released last December by the Office of the Prosecutor of the International Criminal Court. This event is the second one in our series of events devoted to this topic. The first event, which took place about a month ago, focused on providing an overview of the crime of gender persecution. If you're interested in learning more about it, please consult the event recording, which is available on the PILPG website and also available in the chat. These roundtables are also accompanied by blog posts at Just Security. For 4 initial posts, which accompanied the first roundtable, please consult the Just Security website, and the link to those posts is also in the chat. In this conversation, which again is the second in this series of events, we will discuss the deprivation of fundamental rights as one of the fundamental elements of gender persecution through a comparative perspective, focusing on Afghanistan and Colombia. These comparative examples should be useful for the ICC's Office of the Prosecutor, and the ICC's Office of the Prosecutor's policy should also be a useful document to all these national jurisdictions. My name is Milena Sterio, and I'm the Charles R. Emmerich Jr. Calfee, Halter, and Griswold Professor of Law and LLM Programs Director at Cleveland State University's College of Law, and also the Managing Director at the Public International Law and Policy Group. I'm honored to be guiding the conversation with my colleagues today. The Rome Statute of the International Criminal Court refers to persecution as severe deprivation of fundamental rights of the identity of a group. This deprivation has to be intentional and contrary to international law. During this roundtable, our panelists will discuss what constitutes a severe deprivation of a fundamental right and how such crimes highlight the longstanding structural discrimination that women, girls, and LGBTQI+ persons experience. We're joined today by Professor Lisa Davis, Richard Bennett, Ana Elena Bello Jimenez, and Emily Kenney. This roundtable will be 60 minutes long, and we ask that you please submit any questions you have for our speakers using the Q&A function, and we will do our best to answer your questions throughout the event. Now, let me introduce our panelists. We're honored to welcome back Professor Lisa Davis, Special Advisor on Gender Persecution to the International Criminal Court's prosecutor, and an Associate Professor of Law and Co-Director of the Human Rights and Gender Justice Clinic at CUNY Law School. Professor Davis has written and reported extensively on international human rights and gender issues, including women's rights and LGBTQI+ rights, with a focus on peace building and security issues in conflict and disaster settings. I'm also thrilled to introduce Richard Bennett, UN Special Rapporteur on the situation of human rights in Afghanistan. Richard Bennett is a visiting professor at the Raoul Wallenberg Institute of Human Rights and Humanitarian Law in Lund, Sweden, which has commenced an Afghanistan program. He worked at New Zealand's Ministry of Justice and the New Zealand Human Rights Commission before joining the United Nations back in 2000. Welcome also to Ana Elena Bello Jimenez, a Colombian lawyer working as legal officer at the Chamber for Recognition of Truth, Responsibility, and Determination of Facts and Conducts of the Special Jurisdiction for Peace. Ana Elena has also worked as legal advisor of the Deputy General Prosecutor, as prosecutor of the National Anti-Corruption Direction, and as legal officer at the Constitutional Court of Colombia. And finally, welcome to Emily Kenney, a policy specialist, rule of law and transitional justice at UN Women. Emily Kenney has held a number of positions at UN Women, including policy analyst, peace and security and researcher, global study on UN Security Council Resolution 1325. Welcome, everyone, and thank you for agreeing to participate in today's panel. To set the stage for this event, let us first consider all of the elements of the crime of gender persecution and what this first element related to the deprivation of fundamental rights is targeting. My first question is for Professor Lisa Davis. Lisa, could you please briefly describe the 6 elements of the crime of gender persecution as a crime against humanity, and then also give us a little bit more context on this first element and what it focuses on?
Sure, I'd be happy to, and thanks for that, Milena. Well, we know there are 6 elements to gender persecution. 5 and 6, the last 2 are really chapeau elements, so we spend less time talking about them because the more interesting conversation really is with the first 4 elements. The first element is about a severe deprivation of a fundamental right. The second element is about the targeted group. That's the group that was targeted by the crime. Element 3 is about discrimination. So in this case, it's the intent to discriminate based on gender. And element 4 is about how this crime of persecution or an act of persecution has to be in connection to a crime under the Rome statute. Now, that could be an act under Article 7, which is crimes against humanity, or it could be really any crime within the jurisdiction of the court. So when we're talking about element 1, we're talking about that severe deprivation of a fundamental right that's contrary to international law, that affects a person's fundamental rights. So really, we're looking at 3 different components under element 1. We're looking for a fundamental right. It has to be one that's recognized by international law, because it has to be contrary to international law in terms of the violation, and it has to be severely deprived. So we're looking not only for a little deprivation, but a severe deprivation. So what does this mean if we take a closer look? Well, how do we define a fundamental right under international law? When we look to customary international law, certainly rights that are jus cogens are going to meet that standard. Most fundamental rights that we're familiar with and acknowledge are going to meet that standard. They're going to be in that genre of a customary international law right. Most crimes under the Rome statute, then, the prohibition of those crimes or the right to be free from those crimes are going to meet this standard. So the right to be free from rape or enslavement or torture is going to meet the standard for a fundamental right. So in a way, we almost always get to a fundamental right in terms of a severe deprivation, because there's always a connection to a crime under the statute, like element 4 teaches us. So in a way, we get there. But there's something special about fundamental rights in terms of how it's codified under gender persecution that I really want to talk about. Now, to talk about that, we have to take a step back and think about, what does it mean to have a fundamental rights deprivation? Well, we know that most persecutory conduct is enacted through crimes directly, like rape or torture or murder. And we know that those crimes are severe fundamental rights deprivations. So when we're thinking about fundamental rights under the Rome statute, we're looking at things that make sense to us, right? We're looking at the right to be free from torture. We're looking at the right to life, which can be manifested as murder. The right to non-discrimination, which is persecution. But what we don't look at that's so important is other fundamental rights. What about the right to freedom of expression, the right to freedom of assembly, movement, education? These are not rights we typically think of as having a place under international criminal law. And we don't see them in international criminal law. We see them in human rights law. So why do we not think about these? I mean, that makes sense, but we can't, because all of these fundamental rights are really codified under element 1 of the crime of persecution. So when we're looking at element 1 of the crime of persecution, we can look at any fundamental right that's been deprived by a perpetrator when enacting a persecutory act. Now, that is really, really important, because that means when we're looking at fundamental rights deprivations, we need to be looking at all fundamental rights deprivations that are happening in its relationship to a persecutory act. So let me just give you an example so that we can put a little bit of context to this theory. So one example is if a perpetrator intends to limit women's freedom of movement, and says that women can't move freely. They have to have a male family as a member escort them wherever they go. They're not allowed to move around freely. And if they don't follow this, they could be tortured for it. So once you are looking at that act of torture, if you take a step back and you look, you realize, well, there's another fundamental right that's happening here. One is the right to be free from torture, but the other fundamental right is the right to the freedom of expression, and to be able to express yourself, and the right to freedom of movement, the ability to move around, in a context, because that's a fundamental right. And it's being prohibited in a discriminatory way, right? It's being based on gender because it's being applied to women. So we have the fundamental right to the freedom of discrimination, the fundamental right to the freedom of movement, the fundamental right to be the freedom of torture. Okay, we've got 3 fundamental rights. Do they meet a severe deprivation? Absolutely. Torture gets us there all on its own. But if we do an assessment, we may even find that the others do as well. But it doesn't matter, because all we have to do is get to severe deprivation once by any of these crimes, or really by the accumulation of these crimes, of these acts together. So putting all these acts together, discrimination, torture, movement, moving them all together, of course they meet the threshold for severe deprivation of a fundamental right. So that's good. That's important. Now we've got that. Now, what about other fundamental rights? Because what we know about element 1 is we can talk about every fundamental rights violation that happens within that persecutory conduct. So what are other fundamental rights deprivations that are happening when women aren't allowed to move around freely? Well, they might not be able to access healthcare, access food, access the right to employment, civic participation, religious participation, cultural participation. They might not be able to, get an education. They might not be able to do all sorts of things that require the ability to move around, to be able to access those systems. All of those fundamental rights that are being denied through the prohibition of movement, all of those acts come in under element 1, which means lawyers can talk about all of those fundamental rights deprivations in a criminal law brief. We can talk about all of them. And again, that severity deprivation that we have to meet, that severity standard, is met because we get to look at it cumulatively. That's what case law tells us. We get to add up all the fundamental rights deprivations together. And if all of them together meet that severity standard, then we can talk about all of them. And again, remember, we already get there from the torture, because the right to be free from torture and actually being tortured is a severe fundamental rights deprivation. So we get to talk about all of these fundamental rights. The problem is we're not doing it. We're not thinking about how we can use element 1 in our briefs and our talking, because we're not thinking about how human rights comes into criminal law, because it doesn't normally, right? Human rights law and criminal law are 2 totally different tracks, but there's a bridge. There's a bridge between these two pillars of law, and that bridge is persecution. And that bridge is really specifically in element 1, which gives us this chance to put human rights violations on trial and to be able to talk about them in a criminal context. So hopefully that answers the question.
Yes, thank you, Lisa. And we will definitely have time to return to some of these themes throughout this event. My next question then is for Emily. Emily, could you give us some examples of what acts and omissions have amounted to severe deprivations of fundamental rights? What does this mean in practice?
Sure. Thanks, Milena. So the question, in a way of asking for examples, is a little bit of a trick question, because we actually don't have any final judgments from the ICC convicting someone of gender persecution that we could pull from. The first 2 cases involving charges of gender persecution are still making their way through the court. These are the Al Hassan and Abd al-Rahman cases from Mali and Sudan, respectively. And gender persecution wasn't a crime in the statutes of the ICTY or the ICTR, the Yugoslavia or Rwanda tribunals, or the other hybrid tribunals. Those statutes only looked at persecution on political, racial, and religious grounds. The Special Court for Sierra Leone also looked at ethnic grounds. So even though we don't have any examples of ultimate findings from the ICC on what might constitute a severe deprivation of a fundamental right, I think we can still answer your question. And I think I would do this by doing a little bit of what Lisa has just done, but maybe also looking at some of the case law here. So that's breaking the question into two parts. First of all, what is a fundamental right? And second of all, what makes that rights deprivation severe? So when it comes to examples of fundamental rights that we can consider, I think Lisa has already given us a really fantastic overview, but I'll just link it to some of the case law here. We actually have a pretty clear discussion around fundamental rights from a pretrial chamber decision at the ICC from 2017 that authorizes the prosecutor's investigation in Burundi. And in that case, the chamber said, fundamental rights may include a variety of rights, whether derogable or not, such as the right to life, the right not to be subjected to torture or cruel, inhuman, or degrading treatment, freedom of expression, freedom of assembly and association, and the right to private property. And then the chamber goes on actually in a footnote and further elaborates on that list of what we could think about as fundamental rights. The chamber says that it will have recourse to, for example, the Universal Declaration of Human Rights, the International Covenant on Civil and Political Rights, the International Covenant on Economic, Social, and Cultural Rights, the African Charter on Human and People's Rights, the American Convention on Human Rights, and the European Convention for the Protection of Human Rights and Fundamental Freedoms. So that is really a pretty extensive list of existing human rights conventions that the court is saying that it should consider when looking at fundamental human rights. In the ICC policy, OTP policy on gender persecution, the prosecutor adds to that list, actually. And again, this isn't a court judgment. This is the prosecutor's guidance for what could be considered fundamental rights deprivations. The prosecutor adds to the list from the Burundi decision with the Convention Against Torture, the CEDAW Convention, the Conventions on the Rights of the Child, the Convention for the Elimination of Racial Discrimination, the Convention on the Rights of Persons with Disabilities, as well as other rights under customary international law. So the prosecutor thinks that really we should be looking at every major core international human rights convention when we think about fundamental rights. So I would summarize this first question of what is a fundamental right is that it really starts to look like just about every human right can be considered a fundamental right. Then we come to the second part of the question, though, which is what makes a deprivation severe? We aren't talking about just any human rights violation. This is a severe deprivation. And actually in that Burundi judgment that I mentioned, the court itself said, to quote, "Not every infringement of human rights is relevant, but only a severe deprivation of a person's fundamental rights." So I would echo two things that Lisa has really already said about severity. The first is that if we're talking about crimes that are already listed in the Rome Statute, these are by definition linked to severe fundamental rights violations: murder, torture, rape, sexual slavery. These are all by definition severe. But then in addition to that, the second thing to think about is that when you look back at that list of all of the human rights conventions that the court says that it should be looking at, not all of these are acts listed in the Rome Statute. In fact, very few of them are crimes under the Rome Statute. But we have to look at them in context, in their cumulative context and their consequences to understand severity. And this is something that Lisa really has just said, but to link it to some case law, at the Yugoslavia Tribunal in the Krnjolak judgment, the ICTY said that although an individual act may not meet the gravity threshold, the cumulative effect of a series of acts may satisfy this burden. And then in the Kupreskic case, the ICTY said that in determining whether particular acts constitute persecution, the trial chamber reiterates that acts of persecution must not be evaluated in isolation, but in context, looking at their cumulative effect. Although individual acts may not be inhumane, their overall consequences must offend humanity in such a way that they may be termed inhumane. So just to close, I would say that it's quite clear to me, at least, although I'm not a judge at the ICC, that deprivations of really a huge range, really all human rights, can qualify as gender persecution, whether it's the right to freedom of movement, the right to access healthcare. Again, these are things that otherwise would not be crimes under the Rome Statute, but they are when they're committed with this persecutory intent and meeting the other the other 5 elements, I guess, of the crime. In the Al-Hassan case that I mentioned earlier, one of the 2 cases making its way through the ICC that includes gender persecution, in the arrest warrant, the trial chamber summarized the prosecution's argument that, to quote, "The people of Timbuktu suffered violations of their fundamental rights vis-a-vis the rights to freedom of religion, freedom of expression, freedom of thought, freedom of association and assembly, freedom of movement, equality, education, privacy, personal dignity, security, and property." What a list. That is a huge list. And some of them are things that are not even really so explicit in these international conventions, like personal dignity. So again, we have recourse to really an extremely and somewhat open-ended list of rights violations when thinking about what could qualify as a severe deprivation of a fundamental right. Thanks.
Thank you, Emily. My next 2 questions will focus now on more specific examples of Afghanistan and then Colombia. So let me go to Richard next. In recent years, a topic of great focus in the area of rights of women, girls, and LGBTQI+ persons has been the situation in Afghanistan. Richard, how does the situation in Afghanistan help us further shed light on these issues related to gender persecution and specifically the deprivation of fundamental rights? You're still muted, Richard.
Thank you, Milena, and thank you for the opportunity to participate today. Indeed, the situation in Afghanistan does shed light. I expect that participants in this roundtable will be well aware of the situation in Afghanistan, in particular since the collapse of the Islamic Republic and the takeover by the Taliban on August 15th, 2021. Just to start with giving a little context. The Taliban had a previous regime from 96 to 2001, also called the Islamic Emirates of Afghanistan. They were pushed out militarily by the US and the Afghan Northern Alliance following 9/11. They had extreme discriminatory policies towards women and girls and LGBTIQ people back in the 20th century. And during the discussions with the US in Doha, and when they retook power, they promised a reformed approach in which women's rights would be respected, quote, in line with Sharia, unquote. However, their policies and actions have incrementally tracked back to those practiced during the 1990s, including a ban on education and work for women and girls. Moreover, upon taking power in August 21, they set aside the 2004 Constitution, which entrenched equality between women and men. They dissolved the parliament and the Electoral Commission. They fired all the judges, around 250 of them were women, and replaced them with all male mullahs. And they abolished both the Ministry of Women's Affairs and the Afghan Human Rights Commission. The situation regarding law is unclear. Laws which are contrary to Sharia are declared null and void, but a reported exercise to review which laws these are has not produced results so far. And Afghanistan has ratified 7 out of the 9 major human rights treaties, including CEDAW without reservation, and the Taliban de facto authority claims to recognize them subject to Sharia. And Afghanistan has been a party to the Rome Statute since May 2003. Since I was appointed, I've published 3 reports in just over a year, including a recent joint report with the Working Group on Discrimination Against Women and Girls on the situation of women and girls in Afghanistan. All document the deprivation of fundamental rights, describing the widespread and systematic intentional discrimination to which women and girls in Afghanistan are currently subjected. In some ways, unfortunately, this is a textbook example of gender persecution. To illustrate, there's been a relentless issuance of edicts and directives, more than 50, restricting women and girls' rights, including their freedom of movement, dress, behavior, their access to education, work, health, justice, and any participation in public or political life. The restrictions are enforced mainly by the intelligence service. Some were announced as temporary until certain measures are taken, for example, education. But as in the 90s, none have been reversed. And we found that none of the restrictions are either justifiable or reasonable under international law. In their totality, the edicts substantially limit women and girls' ability to engage in society, have access to basic services, and earn a living. In our report, we focused on restrictions to education, work, access to healthcare, including sexual and reproductive rights and mental health, and family and cultural life. We expressed concern about increases in gender-based violence, lack of access to legal remedies, and increases in child and forced marriage. And we observed that women and girls experience multiple and intersecting forms of discrimination that reinforce one another. Hazara Shia, an ethnic and religious and other ethnic and religious minorities, LGBTIQ people, people with disabilities, and human rights defenders may be targeted and are certainly disproportionately affected. And since June 21, women who've led peaceful demonstration demanding their rights have had their and their participation in public life have on numerous occasions been arrested, beaten, detained, and further ill-treated. Many of them have subsequently been released upon guarantees to cease their activism and remain silent about their treatment. Now, to wrap up, we found that the Taliban are severely depriving women and girls of their fundamental rights, including their rights to substantive equality, education, equal participation in economic, social, and political life, equality before the law, freedom from torture, as well as from discrimination and the freedom of movement, peaceful assembly, association, and expression, giving rise to critical concern that women and girls are being targeted for the crime against humanity of gender persecution because of their sex characteristics and social constructs and criteria used to define gender roles, behavior, activities, and attributes. Finally, while our recent report was mandated to study women and girls, men and boys, gender diverse, and non-binary persons may also be targeted for gender persecution in Afghanistan. Thank you. I'll leave it there.
Thank you, Richard. My next question is for Ana Elena and has to do with Colombia. How does the special jurisdiction for peace in Colombia incorporate gender persecution in its laws? And does the special jurisdiction for peace assess deprivation of fundamental rights as one of its elements? And if so, how?
Thank you very much. I'm very happy and honored to share the floor here and discuss this important topic. Well, the special jurisdiction for peace has different sources of law, among which are international criminal law, international humanitarian law, international human rights law, but also national law. We are able to apply directly the Rome Statute. That's why it's so important to address for us as well all the elements of the crime against humanity of gender persecution. On our national criminal code, there isn't a list of all the crimes against humanity, so we don't have in the domestic level these kind of crime. So the Special Jurisdiction for Peace is currently investigating this kind of crime in different macro cases based on the elements of international criminal law. Of course, it's necessary to assess the deprivation of fundamental rights. About that, I will just address very quickly the different cases that are being investigated right now. There are currently 10 cases. Some of them are national cases and some of them are territorial cases. The Chamber of Recognition of Truth and Responsibility, which is the one that investigates these macro cases, these gross human rights violations, is analyzing whether or not to open a national case on sexual violence and gender-based violence. But apart from that, these kind of situations are also investigated in the other macro cases, like cross-examining. For example, so far the one decision charging gender persecution was issued on the case of extrajudicial killings by military members who presented certain people as dead in combat. One of these killings was based on gender violence. This was a victim that had a sexual orientation. It was a member of LGBTQ plus person. And in that case, of course, the main fundamental right violated was life. So some military men were charged because of that, and the way to prove this was because of the hate speech used by the moment of choosing the victim and beating up the victim the way the person was killed. Apart from this important decision, there is case number 2, which is the one I am working in, and now the chamber is precisely analyzing whether or not to charge this kind of crime. And we are investigating a pattern of sexual violence and gender-based violence against women, girls, and LGBTQ people. We don't really use this wording in Spanish. Is a bit longer because we have a broader category called persons with diverse sexual orientation or gender identity. We feel it gets more people, but we can use the LGBTQ in this discussion. And this is a territorial case about the violations committed in Tumaco, Ricaurte, and Barbacoas, which is a region in Colombia. Most of the people in this region are ethnic people, so they are mainly indigenous people or Afro-descendant people. The kind of conducts we have found are rape, killings, forced displacement, inhuman treatment, also a lot of gender-based violence. For example, some women were imposed to cook for the armed groups for several days. They were imposed to domestic labor for them. Also, they were raped, but it was also a pattern related to the gender-based violence and the message of the role of women in their activities. As to the LGBT people, there were some prejudices that have been found. The people who are being investigated, they have said that despite there wasn't a written rule, they would prefer not to recruit LGBT people because they didn't think they would be suitable for the armed group. They would have problems. They didn't think it would be good for the group to have these kind of persons, showing the image that they would have about them. So an important thing about the fundamental rights assessment is that because of the ethnicity of the people, one of the instruments that we do assess is the ILO Convention 169. I think it's very important to be aware of what kind of victims are we talking about. So all these international human rights instruments should be regarded also with the particularity of the ethnicity or the particularity according to the group. If for example, it's about people with disabilities, then you should take a look to the conventions on the rights of people with disabilities. But here, I think it's important to say that we are assessing as well all the fundamental rights, not only as individuals, but as a collectivity, as a group, because these fundamental rights are not really to be evaluated person by person, but the impact in the collectivity as a whole. And in our case, of course, there is a lot of intersectionality in gender persecution, but also ethnic persecution. So when assessing the fundamental rights deprivations, is important to have the view of the ethnicity. We do have a special relationship between the victims and land and their territories and their autonomy as a group, as a collective. So yes, these are some fundamental rights that we are actually assessing. The freedom of movement, because there were some forced displacements, the right to life, but also the right to maintain their culture, the right to keep their traditional and ancestral practices that are very linked to the right to access to food or to education, because they have their own manners to get those, and even their own health system, their own law system. So all these are fundamental rights as well. As I mentioned, the point is to highlight about element 1 that it's important to assess what kind of victim are we talking about, and if we're talking only about individual fundamental rights, or also we may be dealing with collective fundamental rights. Thank you.
Thank you. My next several questions have to do with assessing and proving the existence of the deprivation of fundamental rights. So let me go to Lisa first, and then I'll go back to Emily. So Lisa, how does the existence of discriminatory intent affect the assessment of whether there's a deprivation of fundamental rights for the purposes of prosecuting the crime of gender persecution?
Well, great question. So basically, when we're looking at discriminatory intent, which is element 3, we're looking at that discrimination based on gender for conduct created by the perpetrator, acts or conduct by the perpetrator. And when we're looking at that, we're looking at any fundamental rights violations that are connected to that act or conduct that happened because of that act or conduct. So usually we get to that severe deprivation, like Emily was talking about, you know, when you have a crime. So for example, the act or conduct of committing torture, you know, because a woman's not allowed to move around freely, and this happened, so the perpetrator tortured her. All of those rights deprivations that happened to her because of her right to movement that was violated, you know, is connected to that act or conduct. And that act or conduct that of torture happened with discriminatory intent based on gender, because the perpetrator didn't want, you know, women moving around freely. When we're looking at this, we can also look at that intent and that broader act of that persecutory act, which is the act of prohibiting women from moving around freely. That's also a persecutory act, right? Not just the torture. So the torture is the punishment used when the prohibition on movement is violated. But the actual prohibition on movement is also a persecutory act, which is done with the intent to discriminate based on gender, right? A prohibition on women moving around freely. So when you're looking at that, then your victim group actually becomes much larger, because your victim group is any, women or girl who was prohibited from moving around freely. That could be your group. That's your targeted group. And then it also then says that all, their fundamental rights that were violated from that prohibition also comes into play. So you're looking at a much larger group than just the person who was the victim of the torture. It's everyone else who was also subjected to the larger persecutory act of the policy. Usually they look like policies or regulations, right? They're prohibitions on movement or expression or something like that. We see some sort of prohibition, that's a persecutory act. And then those crimes used to enforce those prohibitions are also persecutory acts. But your targeted group is really bigger. It's really everyone who was subjected to that discriminatory provision. So then you're looking at all the fundamental rights that all of those members of that targeted group also experienced.
Thank you, Lisa. And for audience members, since you mentioned targeted groups, for our audience members, we will actually hold our next event in this series, which will focus on targeted groups on July 14th. So Lisa, don't give everything away today. My next question is for Emily. Emily, from an investigatory perspective, what are the challenges for proving severe deprivation of fundamental rights? What are the most important aspects of investigating crimes of gender persecution in a victim-centered manner?
Thanks, Milena. So I think one of the biggest challenges when it comes to the investigation of gender persecution is that gender-based human rights violations are just so pervasive that they are often invisible. We easily tolerate a certain level of gender-based human rights violations in our societies as the norm. Whether we're talking about access to healthcare or education or the right to participate in public life, there are very few, if any, countries where women, girls, and LGBTIQ+ people don't experience discrimination. So we have this baseline of gender inequality and gender-based human rights violations that make it hard, I think, for investigators to see when things escalate from human rights violations to severe fundamental rights deprivations. In some cases, I think gender inequality also makes it harder for victims and survivors of gender persecution to identify themselves as victims, especially when they might also be experiencing persecution on the basis of another protected status, like their race or religion, kind of like what Ana Elena was saying, that, people are off, as a woman, you might not only be being persecuted because of your gender, but also because of your ethnicity, for example. And many women, girls, and LGBTIQ+ people will see themselves identify themselves more in line with their ethnicity or their religion or their nationality than with their gender identity. Now, when it comes to survivor-centered and victim-centered approaches to documentation, I think that all of the same guidance applies as it does for other Rome Statute crimes. And in particular, there has been a lot of work done around survivor-centered approaches for sexual and gender-based violence, alongside a huge survivor movement. For those who are not familiar with the Murad Code of Conduct for the investigation and documentation of conflict-related sexual violence, I highly recommend you take a look. It's named after Nadia Murad, the Nobel Peace Prize winner, who is herself a survivor of sexual violence. The Murad Code emphasizes a number of key points to consider before starting an investigation, including respecting survivor control and autonomy and ensuring respectful and safe interactions. In addition to the kind of standard guidance around survivor-centered approaches, I would build on something that that Lisa mentioned, that we're talking about really large groups of victims and survivors of gender persecution, because these are systematic crimes, cumulative crimes. One of the kind of core tenets of a survivor-centered approach is that survivors should have a right to participate meaningfully and safely in justice processes and in peace-building processes that affect them. So implementing a survivor-centered approach when it comes to gender persecution opens up a huge new space for survivors, women, girls, LGBTIQ+ people, and of course, male survivors too, to meaningfully participate in transitional justice processes, peace-building processes, peace negotiations. We know that more inclusive peace-building processes are more likely to be successful. So a survivor-centered approach when it comes to accountability for gender persecution opens up so many more avenues for inclusion of diverse women, girls, and LGBTIQ+ people to make our processes stronger and our outcomes better. Thanks.
Thank you. Now, my next question is for Anna. Looking at the crime from a more historical perspective, let us step back just for a minute. How are historical biases and stereotypes impacting the gender persecution crimes occurring presently in Colombia, but also elsewhere?
Thanks, Milena. Yes, definitely there is a huge impact in structural discrimination. In our case number 2, it's very visible. Also, we have in Colombia, you know, the special jurisdiction for peace is the result of a peace process, right? And another institution that was part of the peace process is the Commission of the Truth. You know, they issue a report where they actually mention the impact of structural discrimination against women, against LGBT people, but also due to colonialism, the racism that still exists in our society. So what happens is that there is a colonial view in our society that thinks certain kind of groups are seen as an inferior, right? So this kind of departure point makes that the institutions in the country are different systems are also created like this, and the armed groups also reply these kind of logics in their behaviors and in their thinking. So in our case, for example, the idea of the territories that are ethnic, it's like they feel it's they have territories that are subjective to being appropriated by them. They don't feel it's important to keep the culture of the people who live there, but they feel they have a higher power, or they should help them to organize better or have different kind of rules or to behave. So obviously this is a way to link all the system and structural discrimination to what we actually see in real life. And something that Emily was saying that I think it's very important to be aware of is that a lot of this discrimination is very normalized. So judges should also keep reflecting on their own biases, because it's not easy to investigate a crime when you may also find yourself normalizing certain kind of conducts, right? So it's important to always be just conscious that we are in a system that is still a racist system, despite of all of the efforts that of course are being done, and that we have a good intention, of course. But in general, I mean, this is very normal to happen. So it's not about good or bad people, but more about the system that has already an impact in everything, in law, in everything, right? So in our case, for example, there is a particular impact on women that, for example, the body of indigenous women or Afro-descendant women is seen as very appropriate, right? Sometimes even Afro-descendant women have been hypersexualized. There are different prejudices about these ethnicities that could also have an impact. As I mentioned, that's why intersectionality is so important. And in the end, I would say that it's not possible to really understand the discrimination, which is, of course, the basis for gender persecution, if we don't take a look to the broader picture, to the context, to the history. You can't really separate that. You can't really investigate a certain small thing without knowing what are the roots of all those behaviors. And we have actually, the people who investigate, some of them have recognized expressly, they said that sexism has been part, like now they see it, because before they were so involved in the war dynamics that they, of course, they didn't have much time to evaluate certain rules or behaviors. They were just given. But now they, because of the peace process, they have said, they recognize that sexism has had an impact on different rules and behaviors they had, not only with the civil population, but also inside their own groups. So about the way to show or prove, we also take into account these kind of behaviors inside the group, because this gives you an idea of the way they have the gender roles. So maybe they have something that they did only inside the group, not to the people like the civil society or civilian population, but this gives you a view of their own perspective, right? So it's, I would say it's important to always check. It's not that you're only thinking about what happened to the specific survivor or victim, but more also looking the organization as such, if they had policies, what kind of rules they had, even if it's not the act as such is not connected, but you can find the link about the bias and about the behaviors in general that they would have. And I forgot to mention that because Colombian law is one of the sources that the judges may use, I would say that we can also use all the case law we have on fundamental rights, like the national law and case law as well on fundamental rights. So it's not only for us, at least, what is outside there in international law, but we can also check the meaning and the extent of fundamental rights inside our country. And the Constitutional Court, for example, has done a lot of, we do have a very protective constitution of fundamental rights, but the Constitutional Court has been very active in extending certain fundamental rights. For example, if, you know, like the ones that are not only related to directly protect the person, but maybe social and economic rights, you know. So I would say national law can also shine a light in what should be assessed as a fundamental right. Thank you very much.
Thank you. My next question is for Richard, and it follows up on some of your points, Anna. Richard, in your special rapporteur reports on the situation in Afghanistan, you have referred to the so-called normalization of discrimination and violence against women and girls. Could you describe what this normalization looks like and how it impacts Afghan society as well as women and girls in general?
Sure, thank you, Milena. And you're quite right that speaking before me, Anna and also Emily, have talked about normalization, and they've also talked about I'll coin a new word, invisibilization, the way in which women and girls are made normal, are made invisible through normalization. And they've given good examples of that. We're running out of time, so I could give several, but I think I'll just give one slightly different example from Afghanistan, and that is the way in which men and boys are almost forced by the Taliban to police the behavior of women and girls. I referred earlier to the set of edicts that have been issued incrementally by the Taliban. And under a number of these, the indirect target are the men who are held responsible when their female relatives purportedly transgress the edicts. So the men and boys are often placed in the position of policing the women and girls in their families, thus entrenching a norm that they, the men, are entitled and in fact should control the behavior of women and girls by all means necessary. And this also serves to normalize violence and discrimination against women and girls. I have other examples, but since we're short of time, I'll leave it there. Thank you.
Thank you. And my last question goes to Lisa. Lisa, mindful of the clock here, so could you just in a minute or so tell us a little bit about what do you think these earlier and current precedents of gender persecution tell us about the structural challenges that women, girls, and LGBTQI plus persons face? And I promise that this is not the only minute you will have, because as I announced, our next roundtable will take place on July 14th, and we can certainly continue the discussion then.
Sure. Well, basically in a nutshell, what the policy paper helps to do and what the Charge of Gender Persecution does is it helps recognize the longstanding and historic discriminations that women and LGBT people face. And the best way to analogize that is here in the US, we use the term BIPOC, which means Black, Indigenous, and people of color. And what that term does is it helps recognize that not all people of color face equal levels of injustice. And if we don't have that nuanced racial justice analysis, then we run the risk of invisibilizing how specific histories of anti-Black or anti-Indigenous biases contribute to racially motivated crimes. Well, it's the same with gender crimes. A gender analysis has to consider how misogyny and homophobia contributes to gender-based crimes, or we're going to miss how those crimes work, and we're going to miss how those specific histories have contributed to a continuum of oppression.
Thank you, Lisa. Unfortunately, that's all that we have time for today. Thank you for joining us and submitting your questions to all our audience members. And apologies that we did not get to some of your questions, but as you could see, this discussion was truly engaging. The webinar recording will be available on the PILPG website and shared with all of the attendees via email. This event was part of the PILPG Thought Leadership Initiative. This event is the second in a series of events that we're holding on this policy on gender persecution. And these events are taking place roughly once a month over the course of several months. And as I mentioned, are typically accompanied by blog posts on just security. I'm deeply grateful to our panelists for taking the time today to talk about the International Criminal Court Office of the Prosecutor's policy on gender persecution, and to our audience for their engaging questions. And please join us on July 14th from 12 to 1 p.m. EST for the next event in this series, when we will focus on targeted groups and continue some of the discussion from today. Thank you all and have a wonderful rest of your day.